Here we go. So what we're going to talk about today is where tenants and landlords um, they miss the boat when they're signing paperwork. They think they know what they're signing, or they sign it and they're not really aware of what uh, they are responsible for. And so I want to point those out so that you guys can at least point it out to them and know what they are going to be responsible for when they may not really be aware of it. So this is the lease listing agreement. And on this one, it's our agreement with Bright with us and the KW United and the landlord. And most of this, I think you guys would understand. Yeah, what's the agreement term, the listing term, and all that type of information. One section here that you need to slow down with is what are pets? Because we know we have the whole support animal, and I'm going to get to that one in a moment as well. And part of the challenge is that um, buyers and sellers, by tenants and landlords, the ideas they have of that and what is really the law and what's required. So we'll get into more of that in a second. Um, Broker compensation. I just want to say this: if you're listing for lease, the broker compensation is still connected to the listing broker. So this is not like the sales where the agent has to come in on the buyer side and tell you how much they want. It's still connected. We are collecting A and we're offering out B. And so that is still there. And we have another addendum that started this year on how the tenant agent now has it in writing that we are offering out X, Y, or Z. So the broker compensation is a X% of full month's rent or a flat fee. And then if yeah, and then or other, I don't know why this 30 is here. Sorry about that. And then how long after the listing agreement is over do I still earn that? Usually I put 30 days. And the idea of that being someone saw it through my marketing and we've been on the market 35 days and now they come back and want to rent it. I'm still owed a compensation on that. So from here, we have the broker compensation, and then we have the tenant's broker compensation. It is optional. It is amount taken from the broker compensation, ergo here. Okay. This is how you got to look at these paragraphs in real estate, how they are connected. And so that's where you got to see that, oh, this is still brought from the listing agreement. Okay. Is that me? Yeah. Okay. Anyway, I have no idea what that is. Okay. Something's ticking. I don't know if you guys can hear that on the other side, but we got a ticking noise in here. So, what are you going to offer out? So, let's say that you're doing 100% of the first month's full rent. What are you offering out here of the first full month's rent? Or again, a flat fee or something else, tickets to a movie and popcorn. This will, yeah, that's a good point. It still doesn't show up in the MLS. It's hanging on to the way it used to be, but this doesn't show up in the MLS. So the tenant agent is going to call you and say, "Hey, I'm getting X% from my buyer and or from my tenant, and I want it to be that amount. Are you covering that?" And we'll talk about in the tenant agreement where you can try to get some more money out of that transaction with different types of fees. And then is there additional listing broker if I have an unrepresented tenant? I mean, this was an add-on because before all of this switching around before, it was just like if there's an unrepresented tenant, I just got the full commission. That's how that was. So, but the way this is written, if you're saying 100% of the first month's rent and there is an unrepresented broker, you're already getting 100%. Okay. So it's not like in the buyer broker agree or the seller agreement, I'm charging you 3 bananas that's what you're charging. If you're offering something out to a tenant broker, that is not added to what you keep. If there's an unrepresented tenant, you have to put in there to get extra money. And this one, you're already getting extra money because you're not sending out money to a tenant broker. But it's up to you to decide how you want to do this if you're winding up having to do work on both sides. Broker service fee, if you have that to get me started, or to do the transaction and manage all of that, there's the commission for actually doing the work of the listing agent. And now here's a fee that I might charge to get things going, to get it done. And then do I have a retainer fee to get me going? Okay. So these are two different fees separate from the compensation of the agent. All right. So I'm not doing line by line. I just want to show you a few things in here. That was the compensation. And then what?
From the agent representing the tenant, they can still say in the tenant that he has to recharge or pay in the commission.
If the tenant's unrepresented?
Yeah.
No, if the tenant is represented, they're getting commission from their tenant agent, their rental agent. Yeah, it's still in that agreement. But here, we can offer something or nothing. It's still negotiable for the seller as well. I mean, for the landlord. But it is connected, but it's still connected to how we used to do it on the sales side.
Yeah, because let's say
Mm-hmm.
before I knew how much money.
Yeah, right. In the MLS. Right.
As I'm negotiating, for my commission as representing the buyer, should I do the same thing with the tenant?
Yeah, the tenant agreement is going to say you're responsible for me getting paid whatever we agree to, 30%, 40%, whatever it is. But how I get that is dependent on what we work out. Do I get it from you or do I get it from the tenant agent? I mean, the listing agent.
You have to pay 25%. Seller, a landlord, going to pay me 25%. Can I get it?
Yeah, you collect 10% from the, if you've said 50 and you get 25 from the landlord, you can still get that 25 from the tenant agent. They say, look, I might be able to get something from the landlord, but you still owe me 50% if that's what you're charging. You owe me 50% on this 3,000, so you owe me $1,500. Let me see what I can get from the landlord. Okay, I got $1,000. You still owe me $500. They're still on the dime for that whole amount if you don't edit it. Okay. Now, here we go. Paragraph 17. This is relatively new, meaning the last couple of years, so I keep pointing it out. And where it's a big surprise is if you've got someone that you've done a listing for, and then suddenly you're coming back with this new listing agreement, like, what's this non-resident landlord? It's like, so the non-resident landlord, someone who lives out of state, I got a client like this. They own a property in Sterling. They moved to Florida. They have to have a resident agent. It used to be, it was just a resident agent that they labeled and it was done. Now that resident agent has to be registered with the state corporation commission. Okay. So keep that in mind that's there we go. SCC, boom, right here. I've typed it so many times, it's highlighted. So this is where your landlord needs to register their resident agent if your landlord lives out of state. And remember, Washington, D.C. and Maryland are out of state. We're in the area, but they're out of state. So if they own a property in Virginia, they're renting out, they have to have a registered landlord. It's not a difficult thing. I've looked, the application is not hard. It's really small. It's a $10 fee. And the resident agent does not mean a real estate agent. It just means you're the agent for that landlord in case the tenant needs to get a hold of someone local. Okay. Even if the landlord is self-managing, they got to have a resident agent. If they have a property management company, that resident agent is usually the property management company. Okay. If you're not managing it, which I would submit, if you're not a seasoned property manager, you shouldn't be. You don't want to be the one that people are calling because now you're a year into this thing and they got a problem with the plumbing and they're calling you because you're local and you put yourself down as the resident agent. It's a headache you don't want to put in there. So the non-resident, who's it going to be, Bob? I don't know. Well, let me show you the website where you need to get that registered. And it says here, an office address of resident agent. Office address doesn't mean that this resident agent has to have a business of being a resident agent. That's not what it means. It just means, do you have an office address? And so it could be their house, it could be where they actually work. So let's say they work downtown or something. Well, I wouldn't put a downtown address, but I'd put their home address, or if they work in Northern Virginia, the business where they work in Northern Virginia. Okay. And for protection purposes, if I was going to be a resident agent for someone in Virginia, like my friend or my neighbor, I'd be putting my office address. I'm not going to put my home address on that application. I don't want them showing up at 10 o'clock at night, pecking on my door as the resident agent because that's the address that's there. I want them to come to this location or to Falls Church and go, oh, it's locked for the day. I'll come back tomorrow. That's kind of how that goes. And then what's the email of the resident agent? So in the new listing agreement, like I said, it's not that new. It's been about a year and a half, 2 years now. This new paragraph 17 is there. Okay. Another place where landlords kind of mess up is yeah.
I have a question about that. So what's the risk of that? Because there is a different understanding I had that if there's a problem with that or a lawsuit or whatever, that they'll serve the papers to the resident agent because the reason why it's local is that they're going to be using local laws, not if they're in somewhere else. So
That's
what is
exactly
the
right. And what that is that resident agent is receiving for the landlord. They're not in trouble with what's going on between the landlord and they're not, I mean, they could be cited by an attorney, sure, as the resident agent, but they're not responsible for the lease. They're just the
okay?
one that you come to me and I'll get it to the landlord who lives out of state. That's what that's for.
Because in DC, don't they have? I thought they had like someone else who did. You have to have a license, and then the person who
Yeah.
drew up the license. So that's
Yeah.
the reason why the difference between the two
Yeah.
jurisdictions. Okay,
Yeah,
thanks.
and in DC, there's a property management license and a realtor and a broker, not a realtor, but a licensee license, broker license, and a property manager license. You can't be a property manager in DC without the license. Here, we don't have a property management license. Okay. Lead-based paint disclosure. Okay, that's good. I think that's all I wanted to point out in the listing agreement. Um, Now, in the lease, it gets a little bit deeper for the landlord, and it's up to the landlord to take care of the property and do certain things. And sometimes you'll see landlords and tenants have a like a handshake agreement, which is not necessarily the best way to do things. Always get it in writing. Well, you mow the grass and take care of it's actually in the lease, they'll mow the grass and take care of things. But hey, you do X, Y, and Z, which is not usually covered in a lease. And they just said, yeah, I'll take care of it. And it's a handshake agreement and then it gets messy. So we want to make sure that everything is in writing. Exclusive right to represent tenant agreement. I just want to point out the compensation. So here again, the tenant's broker compensation is on the tenant. The tenant is responsible to pay me for helping them find a property. Okay. If broker receives any compensation from landlord or landlord's representative, that amount would be credited toward tenant's obligation to pay broker compensation. So it's credited toward it. So like you were saying, if you're collecting 50% and you're getting 25 or 30%, they still owe you the remainder.
stay with them 50%, and 25 is gonna be 75%.
No, no. Um, it's just a total of 50% because that's what you agreed to. Yeah. That's the main thing on this one. I'm also teaching our agents we need to start collecting retainer fees because of the loss that you're going to experience with tenants. We all know that. If you've taken anybody out, if you've taken 10 people out, you know you've probably lost 5 or 6 of them. All right. So there you go. One thing is to get them signed up before you really start helping them. I've even gotten away from, sure as that's signed up, I'll set you up a search. I'm not even going to do searches with people. Because I'm like, are we dedicated with each other or not? So my retainer fee is I charge $250. Whatever you want to charge. How much for a rental? Golly, man. That's amazing. Yeah. Yeah, it's a ton of work. Yeah. hmm On the tenant side, you're getting about $1,000. Dang. I want to be you when I grow up. Yeah. Mm.
Yeah.
Yeah. Yeah. Yeah. There you go. Yeah. Yeah. Well, this can be the retainer fee is non-refundable and earned when paid, meaning you paid me, I've earned it. There's no refunds, right? So that's the thing about retainer fee. Well, I probably should. I don't get a lot of renters, so I'm like, I felt like, wow, 250. Like, okay, it's like I was pretty happy with myself. Now I feel like, false belief here. So the retainer fee, I'm all about. You should really start charging that in today's world because there's so many options for them to go out and get something else. And I think there are agents that will, the dialogue they'll use is, hey, look, I know you're looking on other play hot pads and Facebook page. I know you're looking at that. And if you find something, fine, that's fine. But to get me started to work for you, I collect 250, 350, 495, and then I'm working for you. I say, oh, okay. And if they won't pay it, then probably you haven't lost anything because that means it's someone that will find something somewhere else. The last time for me, I was taking some kids out. The kids, I mean, they were adults, but they were renting together. I took them out to so many places, and then, oh, we found something, nothing. I'm like, and I'm coordinating 4 young adults. I was like, that's the last time I will do that. So, all right. And that's the main thing on this agreement is the piece about the compensation. Um, yeah, that's it. I was stupid back then. Oh, I'll be nice. They'll help me out. Yeah. Yeah. I'm just saying that was the one that catapulted me into get it signed and get a check, and then we'll go out. Now, the rest, these other items here, we're going to get into the application. You have found it, and now you're getting into the application for the tenant. We know we have an application. There's an NVAR application. What I would do is submit that to the tenants and say, fill this out. We may not use it, but you at least need to see what's going to be required of you when you get onto it. I mean, has anyone done a paper application lately? No? Anybody online? Have you done a paper application lately, or has they all been online? Yeah, rental application. A paper one? Right. It's online. They're all online. So that's what I'm saying. We have an NVAR application, but it's like, yeah, right. They're all online now. So Rent Risk is online, Rent Spree. If you're doing this through a property management company, most times they have their own application process. And that's why it's important to have a tenant agreement signed because some of these will say submit that so we can see what you've agreed to. So have it signed ahead of time before the application. But the
And
verification, so what, yeah,
the problem with online one though is that one of the documents you ask for is application, and we never get the application. We used to get it when it was paper, but we don't get it.
yeah.
And also they pay credit card, so we don't have that for our
Mhm.
documents, which is
Right.
frustrating.
Yeah. I know I've gotten some success by just hounding them and saying, look, this is required of me by the law to have the application in my file. I must have it by law. And I'll just keep harping them with that line because it's true. I'm supposed to have all the paperwork on that applicant in my files as their licensee. And then the last one I had to do that with, well, we got to check with the landlord. Say, frickin' right, you got to check with the landlord because I, by law, have to have this. And property management company, with all due respect, they know I got to have that, but they're not. Some of them aren't. They're not licensees. They're just a property manager. That's a challenge being in Virginia. But anyway, you just keep banging on the door, and if you need me to, I'll be happy to call them and wave my broker wand and see if I can get it from them. So with applicate, these are the extraordinary or the extra things you may have to have or need with an application. One is when someone is asking for assistance animal, okay? In Virginia, there has to be a verification of disability if there's any question on whether or not they need the assistant animal. So this came about, I believe, 2018. So this has been around a while. So someone says, I need to have this emotional support animal. And what the law now says is that's fine. Fill this out. And then second page, have your therapist fill this out. It has to come from the therapist, not them. Yeah. Because in the verifier, it's telling who they are, what their title is, what's the firm name, what's the address, describe the nature of your therapeutic relationship. Are you providing this via online or telemedicine? In other words, are they an online provider? They're not, they don't have an office down the road. If it's yes, if you answered yes, you must be validly licensed. The last one I had on this one, I sent this out and the person, and I checked them out. Like, okay, it's easy to say yes on this form, but are you really licensed here? And she was a therapist in Florida, which is where I found her address, and she had a license here in Virginia. So she was a verified therapist for Virginia. So she gave me her state license number. I checked it out. State of license where services were provided in Virginia. Yeah, in Virginia. Other states may not have this requirement, but in Virginia, we have this requirement. I think we got overrun in 16 and 17 with people waiving a assistance emotional support animal card that they got online, and they were getting it online with just an online application and no verification that they had an issue. There was no meeting with them. There were these verifiers that would just give you an animal support card. And so I said, that's fine. Are they licensed here? If not, you need to get someone that's licensed here to give that to you. And this is, you'll see in a moment why this is important to have the licensed person, because in the application notice of acceptance or denial, one of them is we couldn't verify that your service provider was licensed in the state of Virginia, or that you had a therapeutic relationship with them. So do they have a physical or mental impairment that substantially limits one or more major life activities? Yes or no? Explanation. Name of requested animal, type and breed of requested animal. Will the animal work, provide assistance? Yes or no questions. They sign it. Then this is submitted with their applications. Okay. So on the listing side, listing agents not knowing this is required if they have an animal. You're not doing your landlord any service but not verifying this. Otherwise, someone is labeling an animal as emotional support and they're not, and then suddenly there's no you can still take action against them because of the animal if the animal messes up anything, but you can't not accept them if you don't have a reason to, according to what you'll see in just a moment. But it's got to be, you need to service this well so your landlord is protected. Now, what is the assistance animal notice? This doesn't mean that they're approved. It's a notice. Approval, great, move along. Denial. The landlord has the ability to verify that the they have a disability that substantially limits one or major life. I wasn't able to do that. Okay. I was unable to verify that the request made reasonably relates to tenant's applicant's disability. I wasn't able to verify that. All of these are connected to that form I just showed you. It wasn't turned in, it was incomplete, which that's a whole nother reason that you can deny people is because their application is incomplete. Landlord is unable to confirm that there's a therapeutic relationship. Landlord is unable to verify that the assistance animal is required to either work, provide. So, backing up to this other one, I was not able to verify that you had a relationship with a verifier. I've also had forms just attached, and the tenant is the one that provided it. I want the verifier to provide it. I want to see fax number. I want to see something on there that it came from a verifier. You know what I'm saying? Like, yeah, here's my address and everything. See my check? Well, you can make a check online and print it out and send it to me and not be a real check. So I want to make sure the verifier is true. Approval of request would pose an undue financial and administrative hardship on landlord. Now, honestly, I got to say, this is a landlord issue. Do they think it's going to be an undue financial administrative hardship? Or would it result in a fundamental alteration to landlord's operations? How does it do that? I don't know. And that's on the landlord. So if a landlord wants to use these two just as a means of like, check that box, I'm not going to accept them. I'll say, well, how does it give you undue financial and administrative hardship? How does it do that? Because they may be putting themselves in legal peril if they don't have a real reason and they wind up going to court. Okay. That is the assistance animal notice. Any questions on those two?
I'm sorry to jump in again, Anthony, but if you use rent spree and you deny them, you have to put a reason in denial.
What's that
So,
again? Where?
so if you're using rent spree, like I use rent spree for a landlord, and we
Yeah.
deny them, you have to put the reason, and it's different than those. But
Yeah. Well, these are the ones that are on the state form, so I think they would be good ones to use.
so
Um,
you have to provide that to the tenant then, so they know.
yeah. Yeah.
Okay.
And now this one is also just the assistance animal notice. We have another notice that's like, I'm rejecting your application. We'll see that one in a minute. Which that's a good. Here we go. Let's pull that one in now. So this one is separate from the animal assistance animal notice. This is the I'm rejecting your application. And Mitch, maybe you can see on this one, these are probably a little bit more well known. Denial. Why? Unit unavailable. Alternate offer or application. Applicant's offer is incomplete. It's misleading. It's incorrect. I mean, this is where people say, yeah, I got one animal. Then they show up with three or two. It's incorrect. And it was misleading. Previous rental history, excessive obligations in relation to income. Their debt to income ratio is too high. Unable to verify employment or insufficient employment. Information obtained through criminal background check. Didn't like that. It would, again, oppose a financial, administrative hardship or result in a fundamental alteration to landlord's operations policies. Do any of these look like what you would have to deal with, Mitch, on some of those? Yeah. Okay. Yeah.
Anthony, I have a question about the criminal background check. So when I check with the fair housing law, you cannot deny because of the criminal background check. And recently, one of my clients went up property. The applicant has a criminal background with the first degree of murder, and but because
Well, let
of
me
that,
check on that one. Yeah. I need to check on the criminal background check. I could see why that would be something that you cannot use, but I got to verify that with fair housing versus what's on this form here. Actually,
Mhm.
let me maybe there's a new form. Let's take a look at that.
My question wasn't referred to that part of the denial letter where it says the criminal, and I got a client that he was denied because of the criminal.
I think there's only one.
Yeah, yeah. I was thinking maybe I had an old one. It's still there. This is from 2022.
Yeah.
So, are you talking Virginia?
Yeah. Mm-hmm.
Huh. I don't know.
Okay.
It does say in that form, information obtained through versus because you have a criminal background. Um, some would say that, yeah, you can't deny it because of a criminal background that they had. But some would also say, but if you're actively a criminal or and define which part of criminal, violent, white collar, speeding problems, destroying of property, which crime are they talking about? Some would say, I know I just finished up my DC continuing ed, and they kind of say, look, you can't take it and reject someone because of something 10 years ago. But if they have an evidence of being a nuisance to neighbors and violence, domestic abuse, you can use that as a means of denying them. I'm hoping that's kind of the same type of thing with Virginia, but I'll check deeper into that.
Yeah, because that applicant has a background with robbery and first degree of murder about 20 years ago. So that was a
Wow.
shock.
Wow. Okay.
But the credit
We'll leave
report,
that
I
one
mean,
there.
credit scores and income's fine. So
Yeah.
this kind of,
Well, and part of it also is incomplete. I mean, I've had this usually happens with management companies. Their application's incomplete, so we went to the next person. And I'm like, and you call your clients, like, did you give it? Well, I was going to get that. It's like, you're not the only applicant. Get it in. You're not complete. And they can reject it because it's incomplete and they're covered.
Here,
Yeah.
information obtained through criminal background.
Yeah.
Back in 2016, when
Uh-huh.
I started crazy idea of being a realtor, I got a client, and I can remember him, Mr. Clark, and he was so excited with the property, and we submitted an application. That was maybe my first rental.
Mhm.
And that was a referral from my broker, that was the owner of the place.
Right.
My first rental property. Then when they send us the deny, they said about the information because he got like a, not that he had, but something about the criminal background. And then I remember that at the office, they said that they are not supposed to
Yeah,
even
I'm gonna have
run
to.
the
Yeah, I'm really gonna have to check into that because here's the thing. Um, it's on an NVAR form, which has been so lawyered over. I gotta imagine that this must still be in there to some sort, but it may be that, like Jason was saying, it's not all crimes. You can't just use it because they're a proverbial speeder. Okay. Right. That's criminal. That's crime, but you know, but and also maybe there's a time limit. But I got to look deeper in that because I do know that crime is not a protected class. Okay. And so the landlord needs to be able to make a business decision based on the character of the person, not just their income and their credit. But I'm going to check deeper into that to find out, well, what does this criminal piece mean?
Because, the landlord is allowed to run the criminal.
Not the
background.
landlord. It would be, yeah.
Screening?
Right. No, I wouldn't say the landlord can run it. That would have to be the background check. Yeah, the screener company. Yeah, because
They
like
allow.
even with like a credit check, you get a credit check, you're not supposed to turn that over to the landlord. We're the ones in the middle. They have a score of 680. We know that we don't want anyone in that's less than 640. So they pass the credit score of what you've said you need to do. There's no state mandated credit score. It's up to every individual. And when all these buyers were not able to get houses, I saw that credit score start going up. Yeah, I got to have a credit score of 700. Got a credit score of 750. I'm like, oh my gosh. And what they were doing is they were grabbing the buyers that couldn't buy who needed to rent something. I will tell you this. I think we got that from the rent risk folks. They did a whole thing on rent and they said something happens under 630 with renters. They proverbially will be late and miss payments when it's under 630. Above 630, it like boom, it just kind of not disappears, but for some reason 630 is the point where you start running into problems underneath that one.
Down or up.
Yeah, the risk goes up once you hit 629. And so that's kind of how that goes. I think one time I'm gonna work out. I'm gonna get Andrew to start coming in, take these hard questions. Let
That's all mine go.
Which, by the way, a little commercial break. Andrew is our property manager for KW United Property Management. I think they think we manage like 70 properties or something. So he's always on the run. Always looks a little haggard because he's got a little baby too, and got another one on the way. So, but he does a good job, and I always refer him out to my tenants or my landlords. So it's Andrew Paxton. All right, and then now we're getting into the lease portion. Wait, not yet. Rental application denial. No, yeah, we just went through that. And then we got the lease. So we've gone through the application process and now we're going to go into the lease. And there are items in the lease that sometimes landlords and tenants don't realize they're agreeing to. Okay. And there's been some tightening up of this since I believe it's last year. Yeah, this year, January. One of them is in the rent paragraph. For the purposes of this lease, all payments, including but not limited to rent and security deposit, will be payable in certified funds. Oh, that's not the one I'm looking for. Here it is. Rent means all money other than security deposit owed or paid to landlord under lease, including prepaid rent paid more than 1 month in advance of the rent due date. So all of that is rent money. Okay. So it just points out to them, this is the new rent money. Late fees. The VRLTA lease abides by the law. This late payment, sometimes landlords want to cross this out and put in more. This is a state mandated fee. You can't do, not that you have to charge this, but you can't go over this. Okay. I want 15%. You can't. By law, you cannot do that. Okay. Notices. Again, notices will be the local address. So back to who's your resident agent. That would be the landlord or the managing agent. You want an address that's local. All right. Security deposit, where that comes, where it goes. A lot of dates in here. All right. Landlord will give written notice to tenant advising the fact within a 45-day period if damages to the premises exceed the amount of security deposit and require services of a third-party contractor. Stuff like this in this disposition paragraph needs to be gone over with the tenant. Okay. Yeah, it really does. And so we want to make sure that the tenant understands you leave tomorrow, you're not necessarily getting your money on the barrelhead. The landlord gets to walk through, see if there's any damage, and then give you the money.
It's not like 45 days.
Within 45 days after the termination of the tenancy or the tenant's vacating premises, whichever occurs last, landlord will provide an itemized statement to be charged to the security deposit. Return security deposit less than any deductions provided. So it's talking about when do you get it. So their last day is the 31st of March. They don't really have to get it back till May 15th. And tenants need to understand that there's a delay here. So they can't think they're going to get the money from here and go make their deposit elsewhere.
Take it from the last one. The last one.
Yeah.
They want to pay 500. They don't wanna pay the last one.
Another thing, tenant will pay the cost of repairs, replacements, or other damages that exceed security deposit. You burn the carpet. It's normal wear and tear is okay, and that's where you might get into a wrestling match with the landlord. That's normal wear and tear. But that's why when you're moving in, pictures of the worn out carpet, pictures of the scratched countertop, pictures of the dings in the walls. Those are the tenant's insurance policy that they're not going to have to take care of these items. Yeah.
So what
Really? You got a question?
What happened when the tenant has lived in the, have been living in the property for maybe 10 years?
Yeah. Well,
They have
yeah.
$1,000 deposit that at this time
Yeah.
is nothing.
Yeah.
So, and they have a lot of.
Honestly, that would be, my gosh, man, if I had a tenant for 10 years, there's a reason I've had them in 10 years. They've been a good tenant. And by that time, this stuff probably needs to be replaced. And that's where I would, if as a tenant, I would have a talk with my landlord, say, hey, I've been a good tenant, right? Yeah, I want my deposit back. And you're going to find some stuff, but we've lived here 10 years, paid rent. We've gone up with you the whole time. We've taken care of the place. I want, and paid off your home. I want my $1,000 back. Okay. So that's where they need to have a discussion early on and not just let it happen, because that's kind of passive, to let me see what happens instead of arguing at the last minute. Okay. Huh? Well, yeah, but I'm just saying it's a tenant that's been there 10 years. And I tell you, when someone comes in and says, well, we're leaving, we need a bigger place, we've been renting, how long have you been renting there? 7 years. And then they say they're Section 8. I tell landlords, you need to grab this one. 7 years in one spot, that's like almost unheard of these days. It means they're a good tenant. So, and now you got the guarantee of the county that's going to make your payment with the next level up. So anyway, it's crazy. Landlord will provide notification and telephone numbers of the new management agent in the event of a change in rental management or the sale. So what's this tell you? Now, in Virginia, when they buy a property, this isn't completely connected to this lease, but when they have a lease and the lease isn't up till, say, it's now what, March, lease isn't up till June 30th, and they sell the property, the landlord can't just come in and kick them out. They can ask them, hey, look, if I gave you your deposit back plus some, would you leave early? But y'all know it's just as hard to find a rental anymore as it is to find a new home. So, but when they buy it, I've had the question, what do I do with this lease? How is that in the contract? And the contract is subject to, in a purchase, to the lease that's in place. What you have to do here, though, is you also have to get the money from landlord A to landlord B. So that deposit money needs to go from Bob Smith to John Jones. And they got to have a way. I tell them, have it done through the title company, and John Jones needs to set up an account. You can't put it in a savings. All right. He needs to have a separate account labeled 1, 2, 3 lowest lane deposits. That's where he needs to have that. But this lease is the purchase of this property is subject to, unless you've got an investor who's just really looking to buy a rental property, this makes it a little bit difficult to sell a house. I had one on the market last year, like in May or June. No, it was colder. So it must have been like October. The lease goes through till this next May, and I just couldn't get anybody to look at it. Numbers didn't work. It was $3,200 a month, but we were on the market for $625, and they said that's not enough money. So then we ended up taking it off the market. Okay. If the landlord has to take money in out of the deposit, they just don't do it. They have to give them a statement of why they took it out. Again, these are things that landlords and tenants, a landlord, if they're experienced, they'll get it. I got to give this to them. The tenant may not understand that. Management office. All right. And then paragraph 7, you're mirroring the same information in paragraph 17 of the lease, of the listing agreement. Who's the resident agent? Okay. Again, this is the one in paragraph 9. If the landlord finds out they lied on the application, it's a reason for them to yank the lease out from underneath them. So don't lie on the lease. Very important. Occupants. So remember, your applicants are not necessarily your occupants. You could have a co-signer on the application who is not an occupant. So you have this section down here in paragraph 10, who are the occupants? All right. Move in. We've talked about this. This is actually a move-in inspection done by the landlord within 5 days after the beginning of the lease for the landlord to give the tenant, here's the condition of the property. Doesn't mean I'm going to fix everything, but here's what I found. And if the landlord's not doing it, then the tenant should do it and give that over to the landlord. This is everything we found with lots of pictures. No reason they can't have pictures in today's world. All right. And that's about all I want to do on this one.
Could you go back over pictures for one time? I'm sorry, I was dealing with something over here. So so the landlord move in, and what about
Yeah.
the land? So I have a client, a real client right now, and
Going?
Long and Foster Property Management has not
Yeah.
given her notice to terminate, and they said at the end of her lease, which is next month, they're going, and they said you should know that they're selling the house. But by the way, you should know, but she doesn't know. But regardless, they said we're going to introduce you to their realtor so they come and take pictures. And she's like, no, no one's coming and taking pictures. You can take pictures after I move. Doesn't she have a right not to have pictures taken? And because that is an invasion of her privacy. And so she and I, I'm telling her, no, you don't need to, you don't need to, they have to come in. You just can't let them, you don't have to let them take pictures of your property. Because it says put on market, it doesn't say anything about, does that make sense?
Yeah,
And
I'm looking that one
she's a,
up here.
she's a government worker, so she's actually pretty, um,
Yeah, this paragraph 27. Landlord or and I'm going to walk through this just so we know we have an understanding. Is it Virginia? It is Virginia?
yes. Uh-huh.
Yeah. All right. So landlord or their designated reps upon reasonable notification and at reasonable times may enter premises in order to do any of the following: inspect, make repairs, supply agreed services. That's all it says.
Right. And then and then where it says, they have to give notice right there, the next one where it says in
Here
addition,
you go. Yeah. For sale for rent sign, put on a lockbox. May show premises to prospective buyers 90 days prior to the end of the lease, to prospective tenants 60 days prior to the end of the lease. Buyer agents and tenant agents are authorized. So if they use this lease, they do have to give them access.
right.
But you're right,
But
it
not
doesn't say anything
photos.
about pictures. I would
Right.
submit, use your old pictures.
Right, exactly. All right, great. Thank you.
Yeah. Yeah, I would agree. It's not in here. And if they push it to say, go to paragraph 27, let me see where you're allowed to take pictures of the tenant's belongings.
Yeah,
Not
because
in
in,
here.
all the government we have, no one wants to take pictures of their private stuff unless they're sellers. So, all right, thank
Right. Okay. Good one. And the rest of this is pretty regular stuff. If the landlord that's their property and they're transferred back, they can get they can get the property back. And then same thing with the tenants. And that's all I wanted to go through on this one. Death of a tenant. If there's only one tenant, they can get out of the lease, obviously. Yeah, I know. Death of one, but not all tenants. The lease may be terminated by any party. Okay. The landlord, death of landlord, lease may be terminated by the remaining landlord or estate of landlord.
For example, I pass and I have the rental with somebody.
Your heirs.
They can see when they can use.
They could. That's where you want to have a living trust and or a resident agent. It's like, yeah. So if you die, I mean, they'll know if there's this aroma coming up, you know, in the, it's like, no, but if you're the only owner, then you need to make arrangements that, hey, if something happens, this person gets a hold of it, have an attorney have it. And there's just expense. I tell people when they want to, I want to be a landlord. So, that's a business. They think they're going to be a landlord and have all this money coming in. It's a business. You have expenses, you got advertising, you got legal documents, you need an attorney. Oh, I can do all that. So, well, something happens to you, who's going to make sure that everything's taken care of on the property? So yeah, death of a landlord. And that's the thing about, let's say you're the only one and you don't have family around that can come into your house and find all your paperwork. That's where maybe a resident agent would be good to have registered with the SCC. It's $10 to register them, but now at least someone has notice to be given to them in case something happens. All right. Okay. That's it on that piece. Now, we're getting into the lease. This form is regularly missing, okay? Because people don't know it's required. It's required by the state. What?
So we're outdated.
Yeah, or outdated, yeah.
I was like,
Yeah. So this is just the Virginia Statement of Tenants' Rights and Responsibilities. And the tenant has rights on the application. They have a right to a written lease, all right? If a landlord fails to do so, the VRLTA still protects a tenant by establishing a statutory lease between landlord and tenant for 12 months. Boom, done. No lease, we got one. Okay. A landlord must reveal certain information to the tenant, visible evidence of mold, name and address of the owner or property manager, and notice of sale or disclosure of the property. Name and address. Some landlords don't like giving this up. No, just give them my email and phone number. That's not what the disclosure says. So you need to push against your tenant, your landlords, when they don't want to give their address. And I get it. Say, well, you need someplace. Where do you work? Give the work address. Where does your wife work? Someone needs to have an address they can go to and mail stuff to. And so they get nervous because in today's wacky world, but what if they show up at my door? Then have a business address, take it to, yeah. If you have a property manager, the challenge is when they don't, and they want to manage it themselves, but they want to be an incognito manager. And that's where you got to look at it and say, this is not what that says. This is a state statute. You want me to list your property and disobey the law? I'm not going to do it. So sometimes in the listing of property, flip this out and let them know what their requirements are. Can you do this? Well, I don't want to give my address. Is that a do or die? Yeah, I'm not giving it. So we need to find another agent. Rental's not worth the rent, the lawsuit.
It can't be a post office box. It has to be actual physical property that they can make delivery of a warrant or whatever, a writ to cure. So people put post office and I'm like, you can't do that. I need somewhere where someone can knock on your door.
Right. Something they can show up to and serve papers, with all due respect. No, it's got to be an actual address. Security deposit. A landlord may require security deposit of up to 2 months' rent. That's it, 2 months. Within 5 days of move-in, the tenant has a right to object to anything in the move-in report. So the landlord's giving them a move-in report. Okay. Hey, and what they might usually protest about is that there's not enough stuff on the move-in report. I'm finding all this other stuff you didn't list, and I'm going to get dinged for it. Okay. The receipts, a tenant is entitled to a written receipt of rent paid by cash or money order. Privacy. May not release information about a tenant without consent. Fit and habitable. Make repairs needed to keep premises fit and habitable. Enforce the right to get repairs. A tenant must be current in rent. So they can't hold their rent to force the landlord to do something. They got to keep paying their rent. And then they got to give written notice and wait a reasonable time. I don't like reasonable time. What do y'all think is reasonable?
5, 20, 15 minutes.
I'd say if it's the air conditioner, furnace, or the refrigerator, it's not, it's like 3 days. But reasonable period is up for debate. Heat and furnace, heat and refrigerator, I'd say no more than 2 or 3 days. Because you're talking about their food and you're talking about their heat, you know? Which, by the way, tenants on their insurance should get coverage that if something happens to what they're renting, they get paid for to go into a hotel. Yeah, renter's insurance, but this is actually, I want to be covered in case I have to move out. So make sure the tenant understands that. I know that a lot of times tenants are like nickel and dime and everything. I said, look, this is when you need it. You need it when you need it. I remember
Listings where actually they say that's part of their,
yeah,
what they're asking for on the landlord side.
Right.
To provide.
that you will have this. Yeah.
That they can be covered, the hotel, I haven't seen it.
Yeah, they can be covered if something happens to their residents.
I
Yeah.
have to pay-
Yeah, probably pay more for that. Yeah. No. So then you call the insurance company and ask them, do you have a rider where if something happens, like the furnace breaks, the house is flooded, there's burn, that I'm covered? Yeah. Well, that's always covered. But this is the something happened and now I got to move out coverage. Because it could be something that's not damaging all the property. It's just like I said, the air conditioner is out or something like that. Uninhabitable dwelling unit at move-in. If this happens, the tenant can walk away, get their money back. It's got all the items, what they can do. I've had this happen about 2 times, once in the last 2 years. Yeah, the trucks outside, they came in and the garage, they were not able to inspect the garage until they were about to move their stuff in. And the other tenant stuff was there. When they moved it, there was mold all over the walls. They said, we're not moving in. We're not even renting this place. We want our deposits back. And that's where this particular company, okay, we'll get it back to you in 15 days. I was like, really? So we hollered at them and had an attorney call them and they released it much sooner than that. Right, because in this one, I'm terminating. Landlord can say, no, we disagree, and then they're back and forth. Repair and deduct. I'd like this one actually. If an issue on the property affects the life safety and seriously affects habitability, and landlord has not begun to address it within 14 days, this is still a little long. The tenant can say, okay, I'm fixing the refrigerator because all my stuff's in the cooler. It's been 2 weeks. This is 14 days, not business days. I got you a new refrigerator for $1,200. Here's my rent for $2,000. I took off $1,200 off my rent because you didn't do it. So they can force them into reimbursing them for things they didn't fix after 14 days of not addressing it. So if it's 14 days, that sounds like that's probably our reasonable amount of time.
It is better to do it through the email and explain the breakdown of stuff, right?
Email it. Or email it, print it out, put an envelope, and put it at the doorstep of the registered agent. Yeah. Eviction, make sure the tenant reads over that. They can't turn off their services, utilities, things such as that. And redemption. A tenant has to have a path to redemption if they're late on rent. They can't just kick them out without giving them a path to redemption. So these are things that they need to know. Again, late fees, insurance, access. Those are the main things. Everyone's got to sign this. Landlord agent. Again, this is not you. It's the agent of the landlord to be the property manager. Because I see this come in and agents have signed this. You're not the agent. Don't put yourself in the middle of that transaction.
Okay, that is if you have been hired.
Thanks, Anthony.